So, hello, good evening, everyone. Warm welcome to the Stockholm SCC Arbitration Institute. Today we will arrange our SCC East-West Forum. This is a third of the series of the event, which is dedicated to current and most topical issues in East-West dispute resolution and arbitration. And today we will speak about the impact of the war against Ukraine on international arbitration. Since February this year, we have faced very big, huge and quick change in rules, regulations and law. And this actually changed a lot on the international arbitration landscape. And we will try to discuss those issues with particular focus on sanctions during today's panel. And today we will have top lawyers from representing 5 jurisdictions, such as Poland, Denmark, Germany, Estonia, and Romania. And they will share their experience from their work with sanctions and arbitrating disputes with sanctioned parties. And I will just now let over the floor to Robin, who will introduce the speakers.
Thank you very much, Natalia, and hello to you all. I'm Robin Oldenstam. I'm the chairman of the board of the SCC Institute, and I have the pleasure of introducing our panel members. So first, to my immediate left here, is Beata Gessel. She's the founding and senior partner at the law firm that bears her name in Poland. She's an international arbitrator who's got more than 150 arbitrations under her belt. She's also a former ICC court member. In fact, I had the pleasure of serving together with Beata for a number of years at the ICC court. She's a member of the ICDR AAA Rules Revision Committee and now also a proud member of our SCC Arbitrators Council. So immediately after Beata, to my left, I have Alexander Foerster. Since about a year, he's an independent arbitrator working out of Stockholm. Previously, and for many, many years, he was a partner with the same firm as I'm with, that's Mannheimer Swartling here in Stockholm. He's both a Swedish advocate and a German Rechtsanwalt. He's got a very broad experience in international arbitration and cross-border litigation for more than 25 years of work. Apart from being also on the SCC Arbitrators Council, he's also a member of the DIS Council and lectures at the Frankfurt University. Moving further to my left, I have Mathias Steino. He's a partner of Hafnia Law Firm, which is a boutique dispute resolution practice in Copenhagen. He's Danish qualified, graduated from Copenhagen University, but he also has studied at the New York University. He's got a very broad experience as both arbitrator and counsel, and is a former lecturer at the Copenhagen University, and again, now a member of our SCC Arbitrators Council. Further, again, to my left, we've got Pirkka-Marja Pöldvere, who is a partner at Ledel Law Office in Tallinn, Estonia. She acts both as a counsel and arbitrator, as well as lecturing and publishing in the field of arbitration. She's co-authored the annotated version of the Estonian arbitration law. She's a vice chair of the board of the Arbitration Court of the Estonian Chamber of Commerce. She's head of ICC, Estonia's delegation to the ICC Commission, and she is also designated by Estonia to serve as an ICSID arbitrator on that panel. And again, of course, now a member of our Arbitrators Council. And last, but certainly not least, Dr. Cosmin Vasile. He's a Romanian lawyer and arbitrator based in Bucharest. He's a managing partner at Sanfiresco, Racotti, Basilia and Partners, and head of that firm's arbitration department. He's got 20 years of experience as counsel in arbitrations, and is also sat as arbitrator in over 50 arbitrations. He, like others here, he's also a member of the ICSID panel of arbitrators. He's also on the roster for the CETAC and SICA arbitrators. He publishes and lectures regularly on arbitration-related matters, and is one of the founders of the Bucharest Arbitration Days. Now, with that, I think without further ado, I'll leave the floor to Beata.
Thank you very much. Thank you very much for inviting me here and for becoming a member of this super circle of arbitrators at SCC. For me, this is a very big honor. What I would like to address here, a few issues, and this is more from the perspective of the arbitrator. I will not be speaking specifically about sanctions. My colleagues, I think, will explore more. I would like maybe more touch base what are the challenges before us, the arbitrators, today. I remember having a case here, like 2 years ago, and we were dealing with the sanctions and the problem of the sanctions only as concerning the new law which was enacted by Russia in terms of the jurisdiction, the exclusive jurisdiction of Russian courts in case of sanctioned entities. And for us that time it was quite an issue to be resolved in our arbitrations. But that was much more like a procedural issue, and I think that now, that from perspective of today, this problem really looks like a very small problem. Because what we are right now facing at this stage, the challenges are growing and growing, and these challenges are really sad. And these challenges, they are not coming out of something like, I don't know, booming development or more objective issues. We were first faced with the COVID issues, and that was much more something like an objective subject. It means the COVID, the regulations that came out of the, not from certain moral justifications, but that was just a disease. No? And we had to deal with this a lot at the level of the procedure. It means we were developing our online and new technologies in this respect. I think that this is a great achievement, by the way, after this COVID thing. And we were dealing with the issues of this extra situations which impacted the performance of various contracts. I'm talking right now about more commercial arbitration. I will not focus on investment arbitration because there is a separate bunch of problems. So we have again now, after February 2022, we have new problems, and this issue of the problems with the changing of the circumstances became, I think, much more complicated than in the era of COVID, because we have right now a lot more. We are going to deal a lot more with some moral assessments in this respect, because the situation was growing, and since February there was a number of different regulations, as Natalia said at the beginning. They were enacted, and certain situations were in before even such enactments were done. It means, for example, the withdrawal, termination of the contracts, which was done for moral principles and not for the only based on the something like sanctions regulations or some other regulations. And how much it is complicated for the judgment, I think that I would like to recall the case which I think everybody is familiar with. That was Anna Netrebko, who is an opera singer and a diva, the opera diva, and she used to be named as a close friend of President Putin. And she was singing in Metz and also in La Scala. And when the war began, when the invasion started, Metz immediately asked Mrs. Netrebko to declare that she protests against the war and her particular appraisal of this situation. She refused, and Metz Metropolitan Opera in New York, they terminated the contract with her. But La Scala, they asked her only to make like one sentence that she regrets that there is so many victims of the war. She was not making any political appraisal in her post on Facebook. So for Metropolitan Opera, that was still something what was not acceptable, and they terminated the contract still. It means they did not withdraw their decision. La Scala said this is okay, and they continued cooperation. Why I'm talking about this? For sure, there was no arbitration clause, as far as I know. That was not judged in the arbitration. But if it comes to arbitration, these are normal contracts, they could come. You see how there will be like challenges in this respect before the arbitrators. How to apprise the situations of these terminations, how to apprise this pacta sunt servanda principles in the so much complicated circumstances around. And the second thing, what I would like to draw, what is, I think, really, it will be important in the commercial arbitration to the much higher level than it was before. This is this impact of the public law. We know that there is EU laws. Well, I came just from London, so they don't know EU law anymore. But here, we must be careful about, the certain mandatory provisions of the EU law, some anti-competition, all of these things, criminal, cases, corruption. But now we will be dealing with more of this public law if we look at the level of all of these resolutions which are being adopted right now about the nature of the Russian invasion. And this will, I think, will have an impact for the assessments also done in the area of the commercial arbitration. And I'm talking about such resolutions like just recently, European Union, the Parliament has passed a resolution about the terrorism character of the financing of the terrorism, supporting the terrorism, that this is the qualification of the activity of Russia in this respect. I think that in commercial arbitrations, we will also have to deal with these issues. It means how much this will impact our decisions. I was very much surprised when I was reading in that the London court. I couldn't really find, because the text of this decision, but there was a court decision which was, that was not arbitration, but that was about the Greenpeace activists who blocked the ship, the unloading of the ship with crude oil on the Thames. So they blocked this, and they were prosecuted and for trespassing. And the judge, that is like a lower level court. That was a month ago. So before any of these, important resolutions were done in the Parliament, in the European Parliament, they have made such a qualification that they released these activists from from being prosecuted because, one, the court said that on the balance of probabilities, I love this expression, in the English courts. On the balance of probabilities, the activity of Russia is a kind of a terrorism, like terrorist activity, a sort of terrorist. That was one point. The second point, on the balance of probabilities, the money which were generated from this oil, which was unloaded, that would finance these terrorism activities. Therefore, the Greenpeace activists were released. So this is what I would like to say, that these examples, they were not exactly arbitration. Well, arbitration is very confidential, so we cannot really talk much about this. But it shows, I think, with these questions which will be raised, and they will be very contextual. It means the answers will be very contextual, because this will be everything based on the circumstances surrounding the various cases.
My question to you, Alexander, whether arbitrators will still be sitting on those kinds of cases.
Yeah, thank you, Natalia. And again, also on my behalf, I'm very happy and proud to be invited to this event here and share some of my thoughts. We had the SAA arbitration days only, I think, 2.5 months ago. And in the Swedish or Stockholm arbitration community, this was very heavily discussed, to what extent it is still possible for Swedish lawyers to accept assignments for a Russian party, either sanctioned or just the Russian party, and also if you can accept an arbitrary appointment. Well, let me start by saying this. It is very important to see that the SCC Arbitration Institute has taken an important step to secure, so to say, the neutral part. You together with other institutions, you took the approach and convinced the European Union to add some very important clarifications to the sanctions so that the arbitration institutes can still work. Sweden as a country, Stockholm as a city can probably not be neutral in the same way as before. Still, they have historically a very important role in the international dispute resolution arena. I think at least the SCC Arbitration Institute can still remain the neutral part and grant access to justice, which is important not only to Russian parties but also to other parties who have a arbitration clause in their contract and need some kind of determination of a dispute. So that first, I think, is very important to see that. Now, will we have sufficient lawyers to act as arbitrators and to represent councils? Yes, I think also there the regulations are sufficiently clear. Still, I mean, there are, that was discussed much at the arbitration days. Larger firms have their problems because they have to take into consideration what other parties, other clients may think about representing a Russian party. So it might be more difficult to actually arrange or assign a topic to a larger Swedish firm. But I think at least when it comes to arbitrator assignments, arbitrator appointments, you can be sure that there will be sufficient names in the pool. I mean, we heard today that the SCC has an informal database with more than 1,000 names, and they will definitely find arbitrators who are willing to accept an assignment in a case which involves to some way a Russian sanction or not sanctioned parties. When you do accept it, then you, of course, you have to think about how should I act as arbitrator. And if you are a lawyer admitted to the bar, you have your bar rules also to consider. They say in Sweden, and I think in most of the other jurisdictions, they are similar, that you must not promote injustice. So you need to see that there are sanctions which are part of the applicable law, and probably also for the law you have to enforce. So in your handling of the case and in your application of the law in arbitration proceedings, I think that means that you need to be a little more active, proactive. I mean, the so far more laid-back approach in many Scandinavian countries, if you compare that to the German, Austrian, Swiss arbitrator, is perhaps difficult to uphold in these kinds of disputes. You need to take a more active approach, proactive approach, and see what actually are the facts in the case, and also you need to consider the mandatory law to be applied. That will, to some extent, change the way arbitration proceedings are conducted in the future, also in Sweden. The last thing I would like to mention, a practical issue which I have discovered also, is the role of the banks. If you have an assignment as counsel or as arbitrator, perhaps in a non-institutional arbitration, somebody needs to pay you. And if the banks are too cautious, they just do not want to transfer any money. And I think that is difficult because they actually then contribute to prevent a party or parties to seek justice. I mean, they need to help within the framework of the EU regulations to make payments allowed also to arbitration institutions and to counsel. But that is still to be seen how they will handle it. I think, and I have listened around in the arbitration community, that that's still a problem when it comes to the Swedish banks.
Thank you, Alexander, for those points. And I think it's important to recognize that although the SCC Institute has managed to navigate these very difficult waters and provide access to its services, there is, of course, a context of many actors out there that all needs to come together to make this work and to bring access to justice. I think, Mathias, perhaps you have some points on that topic.
Well, thank you, Robin, and I would like to echo my esteemed colleagues here for thanking for the opportunity to be here. I'm very, very honored and excited about that. But I will follow up a bit on the issue of access to justice and look a bit more on the effect of the sanctions on the arbitral process as such. It's already been mentioned that it's not it's permitted to act for parties that are otherwise sanctioned in legal disputes, and it's permitted for arbitrators to sit as arbitrators in disputes where one of the parties is a sanctioned party. So, of course, that is a fundamental element of access to justice, that even if you are a sanctioned party, you may not by any means have given a specific reason for being sanctioned. It could just be the mere fact that you are a Russian company. Would you then still have the right to have your disputes adjudicated? And that used not to be a problem at all, because the sanctions, which is of course a very dynamic piece of legislation, the sanctions on the restrictive measures against Russia, which has been developed as an EU regulation, was originally enacted in 2014 with the invasion of Crimea, but has then developed gradually and very dynamically and very quickly, and the latest rules are from the 6th of October. And they extend also to legal services. So the starting point is that as a lawyer, if you're domiciled in EU or working from the EU, it's not permitted to provide legal services to sanctioned entities. But there is a carve-out then in the regulation which stipulates that if it's strictly necessary in order to give access to the courts or arbitral tribunals or administrative proceedings, then lawyers are permitted to act for a party which is otherwise sanctioned, provided, however, that it's compatible to the objectives of the regulation. So the starting point is, you can, as a lawyer, act for a sanctioned party. You can, as arbitrator, sit in a dispute and adjudicate that dispute without infringing these regulations. But there are then certain carve-outs to that. So it's stated in the regulation that it must be strictly necessary, and also that it must be compatible with the objectives of the regulation. Now, I think it remains to be seen what exactly can we put into those generic words. I think it's something that both council and arbitral tribunals will have to review for each dispute where the issue may come up. We can probably easily, using our imagination, come up with examples where you would say, well, this is definitely runs counter to the objective of the regulation. If, by way of example, the Russian government has ordered a missile system from a French defense contractor, then if a dispute arises out of that, then I think no one would be much in doubt that it would be counter to the objectives of the regulation to have someone adjudicate a claim from the Russian government against a manufacturer for faulty missile systems, just to take the extreme. But in between that, of course, there are a number of situations where you may or may not consider whether the result would actually mean that you could potentially violate the regulations. Let's take another example. Again, if we have an emanation of the Russian government which runs a dispute against a German company, it's only about money, but it could be a very significant amount, something that you would never permit to be remitted to the Russian government under the circumstances. Now, the arbitral tribunal and the council would, of course, only be involved in the process of determining the rights and obligations of the parties, which would end up with an arbitral award. The next step, which the arbitral tribunal will not be involved in, is the enforcement. So you may very well have a situation where, based on a sound application of law, the arbitral tribunal will reach the result in favor of the Russian governmental entity. Now, the German company cannot pay up because that's subject to sanctions. But what if that company then has very significant assets in China? Then the Russian government would, based on the wide enforcement of arbitral awards, easily be able to go to China and enforce that award, and would ultimately then obtain payment of an arbitral award that was then rendered, whilst the sanctions were in full force. So possibly that could be something which would have to be taken into account by both council and an arbitral institution or the arbitral tribunal, if there are specific reasons to assume that rendering this award may actually lead to a substantive infringement of the regulations. I'm just using my imagination, I'm just throwing out the examples, but I think it's possible to conceive various scenarios where this could happen. On a different note, and I think it's picking up a bit on this, the question of the morality. Lawyers who involve themselves in disputes where there is a sanctioned party would invariably ask themselves, can I defend this for myself? Is it okay that I'm here acting for a sanctioned entity? Or as an arbitrator, you may say, well, I'm providing the service of distributing justice, but it will ultimately potentially benefit this sanctioned company. Can I live with that? And depending on the circumstances, of course, I think the response to that is that as lawyers, you very often throughout a professional life come across situations where you either represent somebody with whom you don't share ideals or values. I think the most extreme is that if you're a criminal lawyer, you're representing persons who are indicted for various crimes, and they may very well end up being brought to justice for that. But it doesn't mean that they don't have the right to representation. And I think the fundamental right of access to justice, the right to being represented by a lawyer, must still, even in these circumstances, be respected. Of course, within the ambit of the strict rules of what you can and what you cannot, but the morality of it is that everyone, even a sanctioned company, in my view, has the right to have legal representation. So those were my 50 cents on those issues. So.
Thank you, Mathias. And I think we can all agree that representing or being involved with Russian parties really makes you balance on a razor's edge with these sanctions that are not always so easy to understand even. So thank you very much for those remarks. And of course there is the legal theory and form of the sanctions, but then there is the actual practice. And Pirkka, perhaps you can give us some thoughts on that.
Thank you. And thanks SCC for inviting me here. It's always good to be in Stockholm. When I was thinking ahead of what to tell about sanctions and how they are applied and how sanctions are applied in Estonia and how this all works out in the lawyer life. And I was thinking a bit broader than just arbitration life, because the lawyer life has these edges that it's not just arbitration. Then I essentially came to the point of thinking that the key word is acknowledgement. Something that when you think of Estonia on a political level, I think most people in Europe and almost all over the world know that Estonia is very strongly supporting Ukraine. Estonia is very strongly supporting sanctions. And Estonia is also very strongly, on a personal level, supporting in every single aspect that can be. This is also applies on the lawyer level. If you take any lawyer in person, then you pretty much get the same result of the comment. But then you change the personal life, being Estonian, into being a lawyer, and then I think in many cases it actually takes acknowledgement that the sanctions affect our everyday work life as well. Of course, if you have a potential client coming in, or a party to arbitration coming in, that is a Russian state entity, or you can see that the contract is about selling missiles or something, then you of course are red flags up, and you know that this is something that you should either not deal with or be very cautious. But I think there are so many cases that you don't actually realize that this might be about sanctions as well. Just last week I had an example that a potential client was turning to us about representation in arbitration. And there were the client as such would have been an Estonian company. the owners and board members, Russian names, but this is nothing new. There are a lot of Russian names in Estonian companies. So it took me 3 or 4 steps, even me, that I was actually preparing for this seminar at the same time, thinking about it, that acknowledging the sanctions issue is important. It took even me a couple of things, okay, that there might be an issue that I need to double check 3, 4 more steps ahead. There are the shareholders as such, they might be living in Estonia, but the connections might be somewhere. And you really need to go to back to the regular AML checks that who are the beneficial owners. And I think why I'm telling about this is that this is a perfect example of how you actually, in your real lawyer life, don't necessarily think about it all the time. Because the case comes in, oh, I have a new task, that's good, that's great, let's do it. So, and I think the same applies on different levels. It applies on judges, on prosecutors. Not long ago, we had a seminar with the Estonian Ministry of Foreign Affairs and Ministry of Justice, and the joint seminar with judges. And the questions that I raised due to the issues that I had discussed with Natalia and about the arbitration world, they actually started thinking, but they just started thinking about these issues. So it means that there are so many aspects that you might not really come to your mind when you think that you're taking a new task or you're acting as arbitrator. It just, basically it's from a different angle from what Mathias said, that you need to think about it. And I think this is an important message to all lawyers on all levels. Second point that I wanted to make, and I think this is a bit, I'm definitely not opposing Mathias, but I think it's also important that if we're talking about access to justice, which lawyers really like to talk about, and it sounds like morally incorrect for a lawyer to say that this is not important, and I'm not saying that, but at the same time, I think we, as lawyers, should not forget what are the sanctions for. What's the point of it? What's the aim of it? Of course, the sanctioned parties shall have the right for justice and shall have the right for hearings and for cases and all that. But I think it's sometimes with the lawyers being, especially, I'm sorry to say it, with the Western lawyers, being overly philosophical about the rights that are there for persons, tend to forget that not all people in this world, especially from the East, from Estonia, do not think alike. And in many cases, it has proven to be the case that Russians kind of have the drum of, yes, we have to have democratic rights, we have to have all these human rights, but just as long as it suits them. And the moment it doesn't, then they turn around. I know I'm getting on a very edgy topic here, especially among lawyers, and I know that this is also politically edgy, but I think this is something that lawyers need not to forget. Thank you.
Thank you, Pirkka. This is, as I said, all complicated. Since the 24th of February, every single step. Now we have a huge layer of compliance in our everyday life, in our professions, acting as lawyers, representing, sitting as arbitrators. And of course, a huge layer of practical issues on how to implement sanctions, as we have to follow them, we have to implement them. Some special regulations concerning currencies, cryptocurrencies, and one of the most recent ones concerning legal representation, the 8th sanction package, right, Cosmin? Over to you.
Thank you, Natalia. Like all my colleagues, I'm very happy to be here and thrilled to be part of the newly launched SCC Council. And I'm going to discuss also about sanctions, and nothing out of the statement that I'm going to make can be construed as an anti-sanction statement, but rather a critical view on trying to figure out, how to put it politically correct, what can it be improved about the legal regime of the sanctions. And I have picked 3 examples in order to support a sort of a general conclusion. The first one, we are in April 2022, the context of the 5th round of sanctions, and the newly recast Article 5.b includes the prohibition to provide services concerning accounts and wallets of cryptocurrencies for Russian citizens, Russian entities, Russian source, for any value exceeding 10,000 euro. So we have a clear prohibition enacted by means of a European regulation in April 2022, saying that nobody can play with wallets of cryptocurrencies as long as the source is Russian, the source of the money is Russian. And the question is, who does what in terms of actually applying this sanction? Because in that very moment, as far as I know, there are no regulations, EU regulation concerning the cryptocurrencies. So there is nothing one can refer to from an European law perspective as to regulation concerning cryptocurrencies. And if there are national regulations, they are rather isolated. The context is even broader. Later, 6 months later, in October 2022, the European Council approved the so-called MiCA regulation, the Markets in Crypto Assets regulation, which is going to be, when enacted, is going to become the first European regulation and the first time when we are going to have a regulated market, we are going to have scrutiny and control instruments. And now the conclusion is that by means of a European regulation, under the disguise of a sanction, a purely political statement has been made by the European Union, in the sense that European Union actually prohibits the transfer of cryptocurrencies, ignoring, in the context that we all know, the fact that there were no legal tools for the European Union and the member states to actually grow teeth for this sanction to be applied in the moment when it was enacted. The second example, we have witnessed, and I refer only the context of sanctions, to many communications issued by the European Commission. Some of them have become very famous, some of them anticipated the exact content of future regulations and amendments to be brought to certain regulations. My question is, what are they, or how important are they to look at in the context of the sanction? Are there interpretation tools? Are there political statements? Are they even more than this? My example is the following. In April, one of the communications refers to the important topic of screening direct or indirect investments made by Russian foreign investors in EU. And the European Commission acknowledges, first of all, the important number and the value and the economical importance of Russian direct and indirect investments in EU. And then it also acknowledges that there is a regulation 452 per 2019 with the exact object examination of what is called direct foreign investments. And it is also acknowledged by the European Union that actually there is a sort of very difficult to deal with overlap between the idea of screening direct foreign investments and the sanctions. And then what follows is a sort of recommendations, they are called recommendations, this is not positive law as far as I know, whereby the states are encouraged to set up the mechanism they are supposed to set up in order to actually apply the regulation that deals with direct foreign investments, and also all sorts of fine nuances and the red flags are being pinpointed so that the member states deal in a cautious way with this topic. What I have seen in real life and practically is the following situation. Imagine, and this is not an isolated case, I'm pretty sure it happens in hundreds or thousands of cases, a EU company controlled by an SPV or by an entity located outside EU, which is, going forward, controlled by a Russian entity. In this particular context, if you look at the EU regulations, the recommendations and the spirit of the recommendations, and the imperfect and continuously changing national regulations, which are different between various jurisdictions, one may draw the conclusion in that particular case that I refer to, that the idea or the context of changing control of the shareholder of the European-based company represents a new direct investment which is prohibited by the sanctions regime. And again, the question becomes for me, okay, and who does what? How can you prevent the change of control in an entity located outside EU? And how can you somehow create a legal echo to this kind of sanction, as long as there are no provisions, European law or national provisions, that would allow the state to somehow suspend the administration right or anything, and make transform in a concrete way the idea of a sanction. The last point that I'm trying to touch is the already, I would say, more infamous than famous prohibition to provide legal advisory services. We all understand the context and the logic, but my question and the point I'm trying to make is only one. We have heard as early as June 2022 that EU makes a clear point in the sense that in light of the fundamental right to an effective legal remedy under Article 6 of European Convention of Human Rights, this sanction will not affect the right to provide legal services strictly necessary to ensure the defense in judicial proceedings. What I learned as a dispute resolution lawyer when I was young is that a good dispute resolution lawyer is not supposed to push his or her client to push whatever. I mean, your best option in life is to go into a dispute. No, the purpose of a dispute resolution lawyer is to settle in a very efficient way the dispute. If it is possible to explore alternative way, or as a matter of principle, even to avoid the dispute to the extent it is possible to avoid the dispute. The question becomes, in this concrete situation, why is this possibility not recognized? I mean, do we change the perspective on what exactly a dispute resolution lawyer is supposed to do? And the other question is, what is the borderline between what is allowed and what is not allowed? Because my feeling is that as long as you discuss and you suggest or you analyze a strategy for the future arbitration or court case, this is allowed. But if in any way you anticipate a way out that has nothing to do with dispute resolution of the dispute, that is prohibited with all the consequences that are to be drawn from this context. And now, my initial point was that I'm trying to figure out what can be improved if we look at the sanctions regime as a whole. And I would say that they include too much politics. So instead of being purely legal instruments, they do have as a component, as an ingredient, politics. And this is, it may be a matter of taste, I don't like it, or anyway, it is too much for me. On the other hand, they are imperfect legally wise. When it comes to ambit, effects, the instrument, the competent bodies to apply, you don't have to spend too much effort, you are going to find imperfections. There are objective arguments or an objective context that anyone can understand, in the sense that actually this was a legal institution. I think it's a legal institution that occurred out of the bloom under time pressure. So this is a context that justifies the idea of imperfections. But on the other hand, if you look at the way they unfold and the way they are being changed month after month, there is a permanent haste and precipitation. I think this is how you can see it from outside, looking at the regulatory process, the EU enactment process. And I would say that in this case, there are no objective justifications, because it is EU's policy to actually implement a gradual mechanism of increasing pressure. And it is a self-induced time pressure, because they always want to come with new regulations month after month that are generally, or in many cases, imperfect. Why too much politics and this permanent haste are downsides of the regulation? At least for two reasons. The first one, there is a lack of predictability and accuracy, and when it comes to applying them, there are for sure hiccups, and I'm pretty sure that everybody here has witnessed already hiccups when it comes to applying them. And on the other hand, there is a psychological factor. And the psychological factor is the following. What should or what would various authorities all over European Union understand out of this process. And I'm going to provide one example which is illustrative for me, and it convinced me that the psychological factor is important. At the beginning of the war, it was, I think, March or April, in an Eastern European country, there was a sanction, not sanction in the sense of the European regulation, but more mundane. The consumer protection officer went to a store that was selling delicious stuff such as vodka, dessert, and Russian food, and applying the maximum fine to that store. And in a press release, then the guy, it was a man, said that they have somehow to pay the price for everything they do. So his understanding was that a store selling Russian source food somehow has to pay and to be sanctioned in a broad sense for the war in Ukraine. This is 100% the psychological factor and the understanding some people may get from the process. And last but not least, I think that the most important philosophical or conceptual problem with the sanctions is the following. If somebody reads the purpose, the aim, and the logic of the sanctions, I think it is fair to draw the conclusion that they are meant to be, they are conceived to be temporary sanctions. EU does not suggest in any way that the sanctions, all or some of them, are meant somehow to close the problem and to represent the mechanism that is going to represent the bailout from the war in Ukraine. And the problem, if they are meant as a conception to be temporary sanctions, is that temporary sanctions, you freeze accounts, you block some money, you block some assets, they affect in a final irrevocable way some contracts, some deals, some affairs that take place in an unfortunate moment in time. If, and with this I'm going to conclude, if we think and we conceive the European context, not EU, the European broad context, like ecosystem, the reality is that Russia and its entities and its money and its resources are a part of the ecosystem. The sanctions seem to suggest that for the time being and for the purpose totally legitimate of cutting the access to resources, we are going to isolate in a surgical way the Russian ingredient out of the ecosystem. The problem that is that it doesn't work like this. In an ecosystem, which is a live ecosystem, there are all sorts of interactions that cannot be dealt with by simply staying, by means of a regulation, that you isolate them, you take temporary sanctions, and then we will see what's going on. I'm pretty sure there are smarter and better ways to improve the sanctions regime, especially in the context of, unfortunately, long term rather than the expected very short term invasion and war in Ukraine. Thank you.
I have one comment.
I have a small comment as well.
Beata, please.
Okay. Well, I must say that I was listening to Cosmin with great interest, and I think that there was a lot of interesting topics raised. But I would respectfully disagree that in sanctions there is too much of politics, because this is what I understand: is sanctions is the instrument of politics. We are not doing this for regulating like in a normal reality. We are doing this in order to try to shut down the war in the different manners, not only by military weapons. So for me, this is purely political weapon. This is not for economic organization, because if it was not the war, we wouldn't have sanctions. We simply could trade and cooperate with Russia as much as possible. But this is political weapon. So my taste is that this is really political, and this is, yes, it is okay. And the second thing is that this is imperfect. I think that this is the same accusations like with the COVID regulations. We were experiencing this for the first time, really, because we have never had such a big, such full-scale invasion in Europe. And we are right now, it means European Union, at least, we are trying to make efforts. And this is, of course, a game of different interests, because, well, everybody has not everybody, but many people has interest in Russia. So, this is like balancing different interests. And I understand that we are trying to do the best, what can be done in the given circumstances. And it was like stepping ahead because the war started. We thought that maybe Russia would withdraw at a certain point. There was no Bucha. There was nothing like this. And then fact after fact, there are new wave of sanctions. And they are imperfect. And they will be imperfect because we are doing this first time, and I hope last in this century.
Actually, pretty much copying the first point that Beata made, my attention was also caught by the fact that sanctions are too much political and less legal. But I happened to read, for example, the Estonian sanctions law, which is not about specific sanctions, but just what is sanctions. And there is actually a definition of sanctions, which is that it's a tool of foreign policy. So by essence, sanctions are political, and we as lawyers just have to deal with them.
Just a rebuttal of 1 second. I think it is my bad because I was not clear enough. Obviously, sanctions are the legal and political answer, peaceful answer to what is going on. My point and what I don't like is the part of the sanctions that is a purely political statement without the specificity of legal instruments able to produce legal effects. That's the point I'm making.
Respect, we will agree.
And yes, the point I made, and I provide an example where they include in a regulation.
Now our tastes are, in common.
Instead of making political statements separately and enacting regulations only focused on what the object and the ambit of regulation should be, we have a mix. And that's the point I was making. Thank you.
Well, we have had fantastic debate here, and I'm pretty sure we have also a question in the audience.
I have a question to Mathias. You mentioned the case when there is arbitration and that arbitrators should think about possible enforcement in China if a Russian entity has somebody in China and so on. But do you think this is arbitrators' task to think about enforcement after your decision, how it will be enforced, where it will be enforced, and so on? How do you know whether this entity has something in China or not?
Well, I'm happy for that question because it allows me to clarify that. I think the task for the arbitrators will primarily be if it's being brought up, that they may need to include that in their decision on whether to continue the arbitration or whether to include in the award that it's an enforceable award, but subject to lifting of the sanctions. You could potentially draft an award which takes into account suspending enforcement until sanctions are lifted, for instance. I had a case 10 years ago, I think, for a Danish client that had been met with a claim from an Iranian entity that became subject of sanctions overnight. And the Iranian company actually had, in all likelihood, a valid claim against my Danish client. But they couldn't do anything about it, and I think they had other things to deal with at that time, but they didn't pursue it. So we suggested the Danish client, I have to admit now that I was young and perhaps I wouldn't, I'm not sure I would make the same advice these days, but I said, well, why don't we just file a claim before the Danish courts with a negative acknowledgement that the opponent should acknowledge that they don't have a claim against you because they're probably not going to show up. They will have difficulties transferring money to instruct counsel and to do whatever they need to protect themselves. And I think that goes to the core of what I was, the point I was making about access to justice, that you could, by legal means, obtain in that situation what would probably be an unjust result. That particular Iranian company had a valid claim. Maybe they couldn't receive payment at the time, but was it fair to use the rules to get an inverse and unjust result? Sorry, you have a comment, I think.
Perhaps very briefly. I think that is what I meant, that the arbitrator has to be more proactive. It's not just like that the tribunal can wait and see what the parties submit. If there are certain kind of red flags that the arbitration procedure is misused to create a certain result, then you should act. It's the same also with money laundering or corruption. You cannot just wait and sit and say, look, I haven't heard about that, so I will not take it into consideration. If you have a case before you where you can see that the parties are illoyal to the procedure and they are using the mechanisms to get a result which is against the purpose of the sanctions, then you have to act and you have to take it into consideration when you make decisions.
But I still can't see the room for the arbitrator to seek for the assets. That means this is not our role. We have to take care, this is my opinion. Our role is to take care about the proceedings to be properly run, not abused, not overused, and so on and so forth. And I understand corruption, all of these things. Sometimes you have to be proactive, but not in the asset finding. I think that the way how, your example, that is not about arbitrators. This is about the strategy of a council who is running the anti-suit injunction or the negative declaration, as I understand, the negative declaratory relief. So this is the job of the council. And if he comes to me with the application to do something, it means to decide on something, then I will decide. But I cannot make myself, as an arbitrator, the strategy how to shape the award in order to have better enforcement.
Well, I think I agree to the extent that there are limits to what arbitrators need to go out and research for themselves. But the rules apply to anyone who's providing legal services that may violate the regulations, directly or indirectly. So I think as an arbitrator, if you have to comply with the regulation, you must also be attentive to the risk that it may involve a violation. But of course there are...
That's for sure, but I think that the question was a bit different. It means that the question was whether the arbitrator can be more active, if I correctly understood. He can be more active in terms of the potential enforcement in China. That we don't have to think about enforcement in China. We have to think about, in general, the New York Convention enforcement, I would say, yes? And not where are you going, but in particular, where are you going to enforce the award?
But there you have the public policy barrier.
Yes.
And within the public policy barrier, I mean, you have to consider the sanctions because
absolutely,
you should not...
Absolutely, yes. But as I say, I simply differently understood the question.
Well, this is a very interesting discussion.
See, one question, so many answers.
Yes,
you know?
One question and many answers. And here we have another question, right? Krister, comment perhaps.
If I understand correctly, the latest round of sanctions within the EU also extend to lawyers getting involved in arbitrations or other legal matters on the account for the account of Russian clients, and there were certain dispensations. And then the first question would be, could a dispensation be called for when there is an advocate monopoly, which I think there is in Denmark, but which is not in Sweden? That's one question. And the second, then if that is a distinction to be made when it comes to dispensation, how about non-formal but practical obstacles? We have here in Stockholm a number of setting aside actions, and they are in Swedish, so it would form a formidable obstacle for lawyers from other jurisdictions to represent Russian parties. Would that also call for a dispensation?
I may add one example regarding the jurisdictions where you have a mandatory requirement to appoint a lawyer. Like in the Netherlands, there was the case that the Russian Federation had to appeal in the UCOS proceedings, and all the major firms resigned. And then the solution was that the chairman of the bar, the local bar in The Hague, appointed a lawyer to represent the Russian Federation, because there was a need for a lawyer to represent the party. And then, I mean, you are probably exempted from the sanctions. In Sweden, I would say, I mean, you will probably find even in Russia some trained lawyers who are able to speak Swedish. So and I mean the requirements to to represent the party in the Swedish court are not too high for those to achieve. So it should be possible even without hiring a lawyer from a major Swedish firm to be represented in these proceedings.
I can also say in response to the question that as far as Denmark goes, we have a similar system to that in Holland, except that the courts can order a specific attorney to act on behalf of a client who's otherwise unable to find counsel. And I've never heard that being used within the context of arbitration, because it doesn't really come up. But in theory, I suspect you could also make an application to the courts to order an attorney to assist you in an arbitration.
I have a very brief comment for the end, I guess. And I guess it's not a good thing to end with an open question kind of with this seminar, but I think the issues that have been raised right now are really very tricky, because from one side, if an arbitrator, sitting as arbitrator, you actually do realize that the whole point of this arbitration is kind of pocket arbitration to maneuver money from one end to another to a country where EU regulations do not apply. Then to you as arbitrator, the EU regulations very clearly tell that you need to take this into consideration and you shall not be of help for such proceedings. At the same time, then thinking of what are your tools as arbitrator and what can you do? Honestly, I don't know. I don't know what I can do in that sense. If I really understand that if I award this party, then I actually assist sanctioned party to get the money. I don't know what I can do.
This is the same discussion as it was with the corruption. That you remember that I think that was quite a hot topic, for last few years. What to do with the corruption? That means whether the arbitrator can ex officio take the argument what he has concerning the corruption. And I think that the answer is yes, that in this particular situations, in corruption, when you see corruption in your proceedings, then your concern is legitimate to raise it as ex officio. And I think that sanctions is the same problem. That if you see that there is a problem with the sanctions, as you said, that this is shifting money from one jurisdiction to another, then you have to react as an arbitrator. But you have to have but this is my view, that you have to have a really strong evidence in order not to act to the detriment to the parties.
And a lot of courage.
Well, this is a very interesting discussion because it reflects the complexity of in arbitral proceedings now. In addition to the usual issues that arbitrators used to have some difficulties perhaps to decide on, we have, as I mentioned before, a huge layer of compliance, and there is always a fear of an arbitrator there to in some way inadvertently violate one or another mandatory rule, perhaps, if we put it broadly. Thank you so much for your interesting points for this discussion. Really, we are really happy to have you here. Thank you.
Thank you.